Hi, everyone. It's George Belleville here. I'm here with Amy Lazas, our go-to source for anything having to do with estates and planning. And I'm going to ask her a few questions. We've been putting out information about how people can help their family prepare for selling a house when someone gets older and they might need to be involved in the process. So we've prepared a couple questions that we're going to ask her. So first of all, Amy, thank you for taking the time to do this. We really appreciate it. You're always a big support when we need help. So thank you for that.
Of course, happy to be here.
Yes. So the first question I wanted to ask are, what are the key legal documents families should have in place before considering the sale of a loved one's home?
Okay, so before we get to documents, we have to know what condition mom or dad is in. So if there's kind of a path A and a path B, so hopefully people are on path A, which means that mom or dad still have what we call capacity. Capacity is a legal term. So we won't go into that today, but there are, it's not, you know, do you think mom or dad can do it? There are actually some specific legal guidelines for that. Assuming mom or dad do have capacity, because if they don't, none of this stuff works as smoothly and they would need to go down a path of guardianship or conservatorship, which again, probably isn't for today. If mom and dad do have capacity, then you need mom and dad to execute legal documents. The first one would be a durable financial property power of attorney. That document would allow someone to stand in mom or dad's shoes and act on their behalf during any incapacity, right? So if they still have capacity now, but maybe in the future, we're not sure, you need to be able to access their accounts or sell the home for them. You would need to be named the durable financial property power of attorney on that document, and have a relatively recent document will get you the best results. If mom or dad happens to have a trust, then the home, if the home has been retitled into the trust, and if the child is the trustee, the successor trustee, that also works. That actually works better and more seamlessly. When you're the successor trustee on most trusts, you are also the incapacity trustee. So trusts just operate a bit more smoothly. Financial institutions tend to like them a lot better than powers of attorney.
Okay, great. I appreciate that. So the next question is, what is the main legal difference between selling a home through a power of attorney versus a court-supervised guardianship or conservatorship, and why is that distinction critical? And the reason I am asking that question, a friend of mine just went through this in the past year, and it was a tough situation.
Yeah, so like most things in life, when you don't know, right, you haven't gone through it, it doesn't seem like a big deal. When you have gone through it, you realize, oh my gosh, I wish I didn't have to go through all those steps. So a legal guardianship or conservatorship is where the court is going to appoint someone to oversee everything. And it's in fact really to help your parent to be protective of the citizens of Maryland, right? If mom or dad didn't put their documents in place, or if we don't, right, for our children one day, and we get in the situation where they're needed and we don't have the capacity to create them anymore, then the court steps in to protect them. However, that means a lot of looking over your shoulder, a lot of not being in control. And so you don't want to do that. Also, just to get the guardianship or conservatorship is usually more expensive, and it's a process full of conflict. Most people do not want control taken away from them. I actually don't do guardianships and conservatorships for that reason, but I could refer them to someone who does. It costs about the same to put a very thorough and good estate plan in place, and then you have everything that you need. So yeah, don't go that route unless it's an absolute emergency and mom or dad already don't have capacity and they don't have documents.
Right. Okay, great. Yeah, the situation I had was tough because it was fairly quick unfolding, and then they had all these plans to sell the house, and then suddenly no one could sign anything because one of the parents was not available. So it was pretty tough for them, and I appreciate that info. The last question is, besides the standard sale process, what are one or two common legal pitfalls or lesser known details that can complicate or delay the sale of a senior's home?
I think really that might be less legal and more real life and relationships in my experience. I don't know about, you might have had the same experience with your clients. We get random calls from people who want a lot of information, and then you come to find out that it's not them that was named as the power of attorney. It was their brother or their sister, and they're upset. We aren't able to give them any legal advice. They're not our clients, but we get that a lot. So, step one, find out what your parents have and find out if they're able to still create documents. And if they are, do not delay. When you have an older parent, these things can go downhill really quickly. The other thing is families all have different dynamics. It's okay, but you need to be clear about who's in what role. You need to see it for yourself. And before you reach out to anyone, you need to make sure that it's you that's on those documents, right? I don't think this is probably going to be true for many of your clients, but if anyone has ever had any trouble, ever been accused and convicted of anything that's like fraud or stealing or untruthfulness, so maybe that's a sibling of one of your clients, the court will not allow them to be named when that comes to light. So, if you have some leeway in talking to mom or dad, you might want to say, hey, don't put Joe on there because the court's not going to uphold that. He has this conviction for untruthfulness in one way or the other. So name somebody else just to save yourself that trouble.
Yes, great. And that's actually one of the reasons why we started making some of these videos is the issues between the siblings when the path isn't made clear ahead of time. It is one of the big issues that people face. It's really can be tough on the family.
Yeah.
So, well, listen, I really appreciate that information. So if somebody wanted to get in touch with you and talk to you more about this, what would be the best way for them to contact you? What's the best phone number and email that you would like?
Sure. So the best phone number is 443-290-3203. My wonderful teammate Winnie will answer the phone, kind of walk you through our process. And I'd also encourage people, if they are in their 50s-ish or later and they don't have a plan in place, to also consider putting their own plan in place, right, while also helping mom and dad.
Yes, and periodically you do presentations where you have people get together. What if someone wanted to learn more about that and go to one of them? Is that still the best number for them to call?
It sure is. Yep. And also on our website, which is Providence Law Group, I think it might be providencelg.com. They can find us. We're in Columbia, Maryland, off of Columbia Gateway Drive, and we do presentations about 5 times a year, so 10 separate presentations. We're about to do them here at the end of October, but they will be listed. You'll be able to click a button on our website that says register for a seminar if there's one coming up.
Okay, great. All right, thank you very much. I appreciate that info. It was good chatting.
Thanks for having me.